management means I can say that it is no. And we have to have the second one also, namely this what we can say that engineering. Engineering principles or engineering designs have to be incorporated along with the scientific principles and developing a technology, whether it is the water management or the wastewater management, or it is a hazardous waste management or biomedical waste management. We need a good amount of what is a technology is very, 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 very essential for that matter. Okay, with the technology and with the education, can you able to solve the problem of, or can we have a good effective environmental management? Means I can say that to some extent we can have it, but we cannot have absolutely for that matter. We need the third E, namely that enforcement E. What is that enforcement mean? Namely, we have got a certain rules and regulations, certain acts and legislations, and these legislations have to be effectively enforced for that matter. Now, for first and the foremost, in order to have an effective environmental management, we need a good legislations. For the purpose of enacting these legislations, we need a good constitution for that matter. Now, let us see one by one whether we are having a good constitution for that matter. Means yes, I can very well say India is one among the few countries where that environmental protection is being given the constitutional status for that matter. And people can ask, even prior to the 42nd constitutional amendment, whether we are having the provision. But if you could be able to read our entire constitution by not only by the words but the spirit behind the constitution, it is a very much green constitution for that matter. But in the year 1976, through the 42nd constitutional amendment, through articles have been inserted, namely the 48A and 51AG. 48A, it is imposing the duty on the part of the state to protect that environment, and 51AG on the part of the people, that is, it is imposing the duty on the part of the people to protect that environment, 48A and 51G. Then apart from that, we have got a lot of other sections in our constitution for that matter, namely that article 243G in the inserted in the year 1992, entry number 3 for that. What is this? What is that? Land reforms, then land improvement, then minor irrigation, social forestry, then 9th schedule of the constitution in the year 1992, entry number 11, drinking water, fuel and fodder, the entry number 12, then 15 was the non-renewable or the non-conventional energy, and above all that, the 74th constitutional amendment, which is the most important one, it is empowering the Panchayat Raj for the devolution of the powers for that matter. So we have got a good amount of the constitutional provisions available. Then we come to that one, what are the various type of that acts which are there? Yes, we are having a good amount of legislations, and I can classify it in two aspects. One with reference to that the environmental legislations, and another one is the environmental legislations. What is the difference between the and the without the? The is the, we all know the is the definite article, and the environmental legislations are the environmental legislations which have been exclusively enacted for the purpose of environmental protection. What are those? The environmental legislations, we can say that Water Act, Air Act, Environmental Protection Act, Public Liability Insurance Act, then National Green Tribunal Act for that matter. Then we have got another, we have got other one. What is that? What are the other acts? Means that is that environmental legislations. If you could be able to see, even prior to that Water Act, that Sarais Act is there, Factories Act is there, Police Act is there, Indian Penal Code is there, Criminal Procedure Code is there, Civil Procedure Code is there. If you could be able to read the Bombay Colaba Act is there, if you could be able to read those acts, means they are without mentioning that word environment, they are giving that adequate provisions in the various sections for the purpose of protecting our environment, or in the form of public health have to be protected for that matter. If you could just read the Fisheries Act, that the fishes should not be caught during the spawning season, and fishes should not be caught by putting that any explosive materials, because by using that explosive materials you are affecting that ecosystem, and when you are catching the juvenile fishes, it is affecting again the fish population for that matter. Again, when you could be able to see the Factories Act, the factories premises have to be kept neat and clean, whitewashing, then color washing, then the adequate ventilation, adequate aeration, adequate safety measures, adequate health and hygiene measures. All these things have been very clearly mentioned in the Factories Act for that matter. It is all, that is even the disposing of the waste. Again, the disposal of the waste, we can say about with reference to the effluents, with reference to the municipal solid waste. These waste should not be mixed. They have to be treated separately and disposed of properly without affecting the environment. Like that, the various sections are available in the various act even prior to enacting that Water Act for that matter. Now, in the year 1972, we all know that at the international level, for the first time at the Stockholm Declaration have taken place. Under the umbrella of the United Nations, 152 countries joined together and formed a declaration. That declaration with reference to the environment and development. Environment, we call it as a Stockholm Declaration. It is a landmark declaration for that matter. And we all know that in that conference, our Honorable Prime Minister Srimati Indira Gandhi was clearly mentioned in a developing country that it is not only that, what is this one, the poverty or this pollution which is caused not because of the prosperity or because of the poverty for that matter. And again, before that, developed countries have already developed and they can talk about that sustaining the pollution. But we are in the process of development. We have to do some pollution, and without compromising that development, we cannot do for that matter. It was really the keynote speech. The keynote speech was really a landmark speech for that matter. So 1972. Then after that, in the year 1982, the Nairobi Declaration have taken place. After that, 1992, the Rio Declaration have taken place. And in between that, we have got several conventions, several protocols, several covenants, several bilateral agreements, several multilateral agreements with reference to the environment for that matter. Now you can ask me, sir, what is the difference between the declaration and you got at the international level? If anyone could have studied that the international law, means there is a good amount of difference between the conventions, protocols, agreements, covenants, and the declaration. Even in the law, probably you might have heard that hardware and software, hard water and soft water. Like that, in the law also you got a hard law and a soft law. What is a hard law? Hard law is something which has to be enforced. That is, if non-implementation of this law warrants some sort of an economic sanction, or the matter can be taken even to the International Court of Justice also. You are giving some sort of an assurance to the international body that you will be abiding by that hard law after it is being ratified inside your parliament in a democratic country for that matter. But whereas in the case of the soft law, it is more an advisory form. It is not an obligatory form for that matter. Now again, what are the things which have been classified as an hard law, and what are the things which has been classified as a soft law? Hard law is the convention, protocol, agreements. All these things have been classified as an hard law, whereas a declaration is only a part of the soft law. But one thing I can very well say, even after signing the soft law in the year 1972, namely the Stockholm Declaration, India was very much conscious about that environmental protection. In the year 1974, by quoting that Stockholm Declaration in the preamble of the Water Act, it has enacted that Water Act for that matter under the 243, 244 to 245 of the Constitution, article of the Constitution. So now what the point I would like to say, India is very much conscious with reference to that environmental protection. Similarly, in the year 1981, also in the preamble of that act, it really quoted only the Stockholm Declaration for that, even though the Stockholm Declaration happened to be only the soft law. Now coming back to that other type of the declarations, what India has signed in the international level. Now you can ask me, sir, why you are bothering about that international level, international things. Now there are two domains of that law which it does not have a national, slowly the sovereignty of the thing is losing it, and it is going at the international level. One is the environmental law, another one is the cyber law. If anyone could be able to read our environmental law, if anyone could be able to read our environmental law means, and that will be very much a coincidence with the international development which is taking place. Take for example, then what is this one? That conventions. Biodiversity Convention. After signing the Biodiversity Convention is part of that hard law, and India has enacted that Biodiversity Act. Similarly, after signing that Montreal Convention with reference to the ozone depleting substances, India has enacted the special legislations for the purpose of ozone, that is the ozone depleting substances using in the refrigerator and other things. Similarly, after signing the climate change conventions on the Kyoto Protocol, India has brought the climate change policy for that matter. After signing the Basel Convention, that with reference to the hazardous management, India has brought a special rule with reference to the hazardous waste management. Similarly, after signing the Ramsar Convention, we have brought the special rules for the purpose of protecting that wetlands. So, whenever you are signing any convention or the protocol at the international level, you are giving some sort of an assurance to the international body that after signing the thing, after it is being ratified inside the parliament, we will bring a new legislation in consonance with the agreement which you have signed. And if there is no, we will bring a new legislations in consonance with the agreement which we have signed. In the absence of that one, if there is already a legislation is there, means we will be amending this legislations accordingly for that matter. So India is very much cooperating at that international body for that matter. I don't want to say even certain developed countries are not part of the Kyoto Protocol or the Biodiversity Convention or the United Nations Convention on the Law of the Sea for that matter. Okay, so these developments of the international level also contributing a good amount of the international legislation for the development of the good environmental jurisprudence at the national level for that matter. Now, 1974 Water Act has been enacted specifically for the purpose of protecting our water bodies, including the groundwater. Then in the year 1981, namely the GAR Act, then 1986, that Environmental Protection Act. Now, the peculiarity or the speciality of the Environmental Protection Act is that under the Section 5 of that Environmental Protection Act, it gives the power to the executives to make the rules, regulations, bylaws, and the various notifications for that matter. So with that thing, by empowering that, what is this one, that executives, of course it has to be ratified, by empowering these executives, almost we can say that after that it has come to a dead end as far as the legislations are concerned. Then we have got several notifications, several notifications, rules and regulations. To quote a few, I can say with reference to the solid waste management rules, then hazardous waste management rules, biomedical waste management handling rules, coastal regulations on notification, environmental impact assessment notification, public hearing notification. Like that, we are having several, nearly 100 notifications are there for that matter. Okay, now coming back to this one, for the purpose of implementing this act, for a good governance system or the executive system at the central level, namely the Department of Environment, Ministry of Environment, Forest and the Climate Change, at the state level Department of Environment, and for the purpose of giving the clearance to the projects, we have got the state level Environmental Impact Assessment Authority. Then at the central level, you have got the what is this one, that the Environmental Clearance Authority is very much there. So like that, you are having, then at the central level, you got the Central Pollution Control Board is there. At the state level, you got the State Level Pollution Control Board, Central Pollution Control Board for the purpose of policy, and State Pollution Control Board is more for the purpose of what is this one, effectively enacting or effectively implementing these legislations, and non-compliance of this one, giving the powers to the various Pollution Control Board to take appropriate legal action against the erring industry for that matter. Okay, sir. Now we come across, that is the governance part or the executive part. Now, whenever that law is there, if that law is not in consonance with the Constitution, or if it is affecting any one of the fundamental right, and if it is misused or abused or overused, then the matter is being taken to the court, and the court also not only interpreting that existing law, but innovatively interpreting that existing law, and it has created or where it has made certain, novel principles and the doctrines for that matter. To quote a few for that matter, that sustainable development. In fact, people will say in the year 1992, after the Rio Declaration, only the sustainable development word has come for that. That is the development which is taking care in fulfilling the needs of the present generation without affecting in fulfilling the needs of the future generation. This is what the definition is being given. But I can very well say, even prior to that, in the year 1986 itself, in the Vellore Citizens Welfare Forum case, Justice Kuldeep Singh, in the course of judgment, he has very clearly mentioned, as long as this principle that only the sustainable development is not contrary to the municipal law, it is nothing wrong in infusing this principle into our domestic legal system or into our municipal law for that matter. So automatically, sustainable development principle has been infused into our judicial system even in the year 1986 for that matter. Then apart from that, sustainable development is just like a tree. Then when you wanted to have the wholesomeness, means there are other branches or the root system. What is this one that like a human body, we have got the various systems: circulatory system, nervous system, brain system, the reproductive system. Like that we are having, then only the whole system will be functioning properly. So similarly, when the sustainable development has to sustain, means the judiciary has set various principles for that matter. What are those various principles? When you see, means number one, the precautionary principle. Number two is the polluter pays principle. Number three is the intergenerational equity. Number four is the public trust doctrine. Now, what is a precautionary principle? When there is no scientific evidence is available, you know that the environmental laws are criminal oriented. You have to go as per the criminal jurisprudence. You have to go by the necessary evidences and witnesses. But scientific things is going on developing. If erring in industry, if a pollution control board wanted to prosecute, means then, or if anyone wanted to say that a particular effluent which is being discharged by the industry is causing or is likely to cause certain diseases, then we have to prove it. If in the absence of proving it, you cannot prosecute them and punish them. But proving is a very difficult thing because the science is going on developing. For that reason only, the Supreme Court in the MC Mehta versus Union of India case has very clearly, Shriram gas leakage case, it is very clearly mentioned that in the absence of the scientific thing, we cannot take a negative decision. We have to follow the precautionary principle and stop the project for that matter. So this is one of the landmark judgment for that matter. Similarly, when you come across the number two, namely the absolute liability, even in the developed countries, they are following only the strict liability. What is the difference between the strict liability and the absolute liability? In the case of strict liability, you got certain exemptions are there, like act of God, or what is this one, act of an enemy country, or that act of what is this one, without the knowledge of the industry's people, something is done, means they are not responsible for that. But again, by following this absolute liability principle, they are liable to pay the compensation for that matter. Similarly, the sustainable development, again I told you, then we can come across the what is the polluter pays principle. The Vellore Citizens Welfare Forum case, the Supreme Court has said the polluter, one who is polluting, has to pay for that matter, but it does not confer the right to pollute for that matter. That is the polluter pays principle. Based upon that, we are collecting now at present also, we are collecting several compensations from the industries for that matter, for the purpose of violation of this one, as well as for the polluted thing also. We are working out a special formulas are available for that, and we are collecting that money, and that money is being used in order to retrieve back to the original condition of that damaged site for that matter. Then you come across the public trust doctrine in the Kamal Nathwa's case, namely that government is not the owner of the property, government is only the custodian and guardian of the property, or government is only the trustee of the property, and everyone, and it has to be used only for the purpose it is mentioned for that, and it should not be misused or abused or overused for that matter. So this is one of the landmark judgment. You have all heard about the private trust only. For the first time in the entire country, this public trust doctrine has been infused into our environmental jurisprudence by borrowing this principle from the American jurisprudence for that matter. Then you come across intergenerational equity. That is nothing but We are only we borrowed our environment from our children, not inherited from our parents. So we have to leave that environment as it is. We have got it to our next offspring or the next generation for that matter. Okay, apart among all the most important one is, even though environmental right is not mentioned as one of the fundamental right in our constitution, but Supreme Court innovatively interpreting the constitution and very clearly said that environmental right is also one of the fundamental right under the Article 21 of the constitution, namely that environmental right. Non-provide, then automatically we can interpret it in other way. Non-providence of the clean and healthy environment by the government or by the state is violating of one of our fundamental right. So whenever there is a violation of the fundamental right, you got another right under the Article 32 and 226 of the Constitution to approach the highest judiciary and get back your right for that matter. So this is one of the most important one. Environmental right is one of the fundamental right for that matter. So that as far as India is concerned, that Indian judiciary has contributed a good amount of thing for the purpose of effective environmental management. But again, we are having certain loopholes in our laws also. Take for example certain rules. We can say that the environmental impact assessment notification, if you see it, it is more an industry specific, it is not a site specific for that matter. So inside that site you can give any number of that industry if it is within the permissible limit, but overall carrying capacity of that particular area or the particular system, we are not working out and giving that for that matter. Similarly, that we are not doing about the economic value or that environmental damage, we are not calculating that economic value for that matter. Similarly, environmental cost is not included in the waste disposal cost for that, or in other words, we can say that internalizing that externality which is not being followed in India for that. Then policy EIA, namely the governmental policy is not subjected for that environmental impact assessment for that matter. Then if it's subjected to the environmental impact assessment, then calculating the economic value of that one means then whether the particular policy is environmentally feasible and economically feasible, that we are not doing for that matter. Then again, we are not doing for the carrying capacity. Like that, we are having so many things. Because of the already I have taken nearly 22 minutes for that matter. Now, let me put a full stop at this juncture. If any questions, doubts and clarifications, you are most welcome to ask me either through orally or by through my mail ID also. So once again, I would like to record my sincere thanks to the organizers of this program for having given me this opportunity. And secondly, I would like to congratulate and extend my best wishes to the organizers that they are conducting such type of webinars at the national level in order to sensitize the younger generation. And because see, most of the people are celebrating all other days, then only very less people are celebrating that World Environment Day, including the environmentalist. At this juncture, you are organizing and inviting a person from the southern down south of the map of that India means really I am feel very proud, pride and pleasure for that matter. My best wishes to you, sir. Thank you so much.
Thank you, sir, for your valuable presentation. Now, our next speaker is Dr. Wahid Ali Panwar, sir. He is an associate professor, Department of Geology, University of St. Jamso. And Dr. Wahid Ali Panwar is a distinguished entomologist and geologist with over 10 years of PhD teaching and research experience. He earned his PhD from the University of Sindh in 2015 and specialized in insect biodiversity, systemic and ecology, particularly Opthera. He has published approximately 140 research papers, authored 2 books and 2 book chapters, supervised 6 PhD and 43 MPhil scholars, and secured 7 national and international research projects. His contribution include the discovery and documentation of